The National Labor Relations Board has served up a victory for fast food workers fighting for better working conditions at McDonald's. But the world's largest restaurant chain says it's fighting back. Both sides agree if the finding stands, it could change the balance of power in an industry that employs 1 in every 10 American workers. Scott Cohn has the story.
The fast food workers say they're overworked and underpaid, and they've been protesting.
The people united!
McDonald's says it doesn't set wages and hours, its franchisees do, and they're independent. But the National Labor Relations Board says that's not exactly the case. In a 2-paragraph statement, the NLRB's General Counsel's office says McDonald's corporate is a joint employer, potentially liable in dozens of allegations of unfair labor practices. Labor advocates say it's a step toward a much bigger goal.
The ultimate goal here is for fast food workers in the U.S. to get $15 an hour and to have the right to form a union without retaliation from their employer.
But who is their employer? For decades, the industry has operated on the idea that it's the franchisee, and McDonald's has more than 3,000 of them. But the workers argue that corporate headquarters controls virtually every aspect of a franchisee's business, including their profit margins and, by extension, the wages they pay. McDonald's says it will fight, says the decision changes the rules for thousands of small businesses. The National Restaurant Association agrees, says the ruling will give franchisees even less control than they have now, and it'll cost jobs, not just in the restaurant business.
We're talking hotels, we're talking healthcare, we're talking in a number of other industries as well.
Any business that uses the decades-old franchise model. One reason this decision could ultimately wind up in court. Scott Cohn, Nightly Business Report, Englewood, New Jersey.
We have 2 different points of views on this subject tonight. Stephen Caldera is the president and CEO of the International Franchise Association, and Michael Rubin is an attorney at Althusser Berzon, who is also a lawyer for the McDonald's class action plaintiffs in California. Mr. Rubin, I'm going to start with you. This is a big win for your side, is it not?
This is a huge win. It's important not only for the workers who are involved in these NLRB cases, but it will impact McDonald's workers and fast food workers throughout the country.
Mr. Caldera, I don't think I'm going to have to strike the match more than once here. I think you disagree with Mr. Rubin. My question for you, though, is why wouldn't franchisees want to share some of the liability with their potentially more financially strong and well-lawyered parent companies?
Well, Tyler, there's a reason why the franchise industry is outpacing the growth of the overall U.S. economy, because it's a proven, time-tested model. It's a way for aspiring entrepreneurs and existing franchisees to be in business for themselves, but not by themselves, because they get certain support from the franchisor, which they pay initial franchise fees and ongoing royalty fees. And so given the fact that we create jobs and business, small business ownership opportunities for all folks, diverse folks, whether they're veterans, minorities, all Americans, is a great story. We represent 3.5% of GDP, and that's pretty significant. And to hold McDonald's accountable for the alleged labor violations of their franchisees, we believe is, ill-advised and just isn't true.
What about that, Mr. Rubin? I mean, there are those out there who say that this will hurt franchisees, not just at McDonald's, but if this case is applied to other franchise entities, that it could really basically thwart competition and make it prohibitively expensive for people to buy franchises.
No, the problem here isn't the use of the franchise model, it's the abuse of the franchise model. McDonald's exercises an extraordinarily detailed degree of control over every aspect of its franchisees and their crew members. It has ongoing real-time computer monitoring that lets it know at every moment how many workers are working, what they're being paid, whether they're entitled to overtime, and it instructs its franchisees that if the labor costs exceed a certain fixed ratio to the income that franchisee is receiving, then the labor costs have to be cut. McDonald's is not a typical franchisor in that respect. It has people going into each of these restaurants, interviewing workers, telling them what to do. It's employing those workers.
But
the workers know that McDonald's is doing that.
If I'm a shareholder, though, of McDonald's, I might look at those practices and say, you know what, that's good corporate governance. You're keeping your eye on your costs. You know what your franchisees are doing. You have quality control over the product, et cetera. What's your response to those criticisms?
When a company engages in the pervasive degree of control and micromanagement that McDonald's exercises in the workplaces, it is an employer. It's an employer under the National Labor Relations Act. It's an employer under state law. It's an employer under federal wage law. These are not new principles that the Board General Counsel is pursuing in the complaints that were announced yesterday. These are well-stated, well-established standards that fully apply to McDonald's based on a voluminous factual record that the General Counsel has carefully examined.
Address that, Mr. Caldera. Mr. Rubin is saying that, in fact, in practice, McDonald's in this case is, in every material way, an employer just in the same way as the franchisee, because McDonald's is controlling the labor practices. What do you say to that?
Well, I would argue the fact that the franchisor's responsibility is to ensure brand standards are met, to protect good operators, to ensure consistent quality of the products and services that they provide. And I think it's important to state that these franchisees, and again, outgrowing and outpacing the growth of the U.S. Economy the last 5 years, are independent operators. They put up their own savings. They take out loans. In some cases, they do both. They have the ability to hire, fire, set wages. They process their own payroll. They are given an employer identification number by the Internal Revenue Service. And to hold them accountable would push back decades-long precedent that defines them as independent operators. And all we have to do is look at the Small Business Administration, how they define franchises, the Federal Trade Commission, the Internal Revenue Service, as I just mentioned, federal and state courts, and the NLRB for that matter. What this really is, in my respectful opinion, is a way to put more money in the union coffers. It's easier to organize when all the franchisees are lumped together as opposed to one-off mom and pop shops. And I really think that's what this is all about.
Gentlemen, we'll be following this very closely. Thank you both for joining us.
Thank
Appreciate
you.
it very much.